Please be seated.
We'd like to welcome you all today to the final of the Osborne Clark Internal Mooting Competition. First of all, I'd like to thank all of you for coming to support, especially members of Wellington College and the Embrook School who have come to see us, and also Osborne Clark, our fantastic sponsors.
We'd also like to welcome competitors. We've got Rebecca Neville and Amy Wells for the appellants, and Ian Shirley and Kimberly Morton for the respondents. Most importantly, we'd like to welcome our judges for this evening, Ben Douglas-Jones and Alan Richards, who will be judging the moot. If everybody is ready, we would like to welcome Rebecca Neville to the bench.
If it pleases your lordships, my name is Rebecca Neville, and I am here as the senior counsel on behalf of the first appellant, Mr. Bain. My learned junior, Miss Amy Wales, accompanies me and appears on behalf of the second appellant, Dr. Geller. My learned friends, Mr. Shirley and Miss Morton, who appear today on behalf of the respondents, the Crown. Today, my lords, I shall be dealing with the first grounds of appeal. That is, that the direction given at the trial of Mr. Bain was inappropriate, as Mr. Bain could not have intended a result that it was his ultimate purpose to avoid. My lords, the direction given at this trial was based on that formulated from the case of the Crown and Willen, and I shall therefore be submitting today that the jury is entitled to convict the appellant of murder on that basis, as the jury cannot find the necessary intention needed here, due to the fact that the situation at hand varies enormously from that of the Crown and Willen. If I may proceed, your lordship.
Yes, Miss Neville.
My first point of submission, your lordships, is that the jury cannot find the necessary intention needed in order to convict the appellant of murder. If I may refer your lordship to tab A of your bundle, behind which can be found the case of the Crown and Willen, to page 11 of the case, to the section highlighted in pink where Lord Stein states his desire to change the principle set out in the case of Nedrick. Glanvin Williams, Professor Smith and Andrew Asworth observed that the use of the words to and fair may detract from the clarity of the model direction. I agree. I would substitute the words to find. My lords, this principle from Willen states that the jury are now not entitled to find the necessary intention unless they feel sure that death or serious bodily harm was a virtual certainty. My lords, if we apply this to the case at hand, it can be submitted that the necessary intention cannot be found.
Well, Mr. Bing has accepted throughout these proceedings, hasn't he, that he appreciated that it was virtually certain that his son would die, and indeed that he and his daughter would die if they jumped out of the flat. Is that right?
Yes, my lord, that's correct. However, given the situation given, Mr. Bing had no other option available but to do this. My lord.
Well, that's a slightly different question, isn't it? That deals more with the issue of necessity. If we're basing this part of the discussion on the reasoning in Woolen, is it not right that the Woolen criteria are satisfied here?
Yes, my lord. Here it is satisfied. However, the facts of this case are somewhat different compared to the facts of Woolen, and I shall be making this point in my later submissions. My lord, here the fire escape was blocked by a wall of flames. The appellant had no safe or reasonable way to get out of the flat. Having realised that the fire was approaching him in the flat, the appellant retreated to the rear of the flat, as there was nowhere else they could go. My lord, the appellant faced two choices, both of which death would ultimately be a virtual certainty. He could either stay in a flat with a blaze of flames approaching them, where Ross, a tiny baby of only 3 months old, with minimally developed lungs, would surely be dead within minutes. Or he could throw the baby to the crowd that gathered below the window, where there was a slight chance that the baby would survive. My lord, the appellant, after thinking about this, concluded that throwing Ross to the crowd was the only option available to him at this time. My lord, given this fact, my learned friend and I therefore submit that the intention cannot be found here, as no matter what option the appellant picked, death would ultimately be a virtual certainty.
Can I ask you how you would reformulate the will and direction in those circumstances so that we can see where you're going in terms of how you'd seek to develop the law?
Well, my lord, here it needs to be changed that it needs to allow for situations where, yes, there's no other choice, where death is ultimately a virtual certainty, and there therefore needs to be an allowance in the law which enables clients with no other chance, but where death is virtually certain, a defence to them.
I think we can see that there's a qualitative difference between the two cases in terms of why the child was thrown. But is there a rider that you'd want to add to the Woolen test? Or is there a way in which you'd like to change it so that we can see exactly how you want us to direct the jury?
Well, my lord,
in Woolen, clearly the child was thrown to the ground with temper, whereas in this case, Ross was thrown from the window in an emergency situation.
yes, my lord.
Is there anything that you'd want to develop in terms of emergency, or is there something qualitative that you'd change in relation to the Woolen test itself?
Well, my lord, there needs to be an alliance, a change made to the difference of intention, because it's evident here that there was no intention needed. It was a father merely trying to save his son, and there therefore needs to be an alliance made in the law for these emergency situations where death is ultimately a virtual certainty.
I appreciate that that's the result you're aiming at, Ms. Neville, but what's troubling me is that whether the resolution, if we feel it appropriate, is to say that Woolen was wrongly decided to some extent, or whether in fact we should respect the reasoning in Woolen, which has stood for some 14 years now, and you'll be aware, of course, that the state of the law of homicide prior to that time was in some considerable flux. Whether we should respect what the House of Lords said on that occasion and seek not to amend the existing Woolen test, but to supplement it in some way, and whether or not, in fact, the answer lies not in a reformulation of Woolen, but in the doctrine of necessity. Do you say Woolen is in any way wrong?
For the case at hand, my lord, yes, I would submit that Woolen cannot be applied to this case at hand.
Well, I appreciate you don't favour the application of the Woolen test in the way that the judge directed the jury in this case, but stepping back from the particular facts of this case for a moment, do you say Woolen is wrong?
Yes, my lord, I would
Right.
submit.
How is Woolen, objectively, in isolation, how is Woolen wrong?
Well, my lord, it is wrong because it says that proof of foresight, the fact that virtual certainty, that proof of injury or death is a virtual certainty.
I think
Sorry,
one of
could you repeat the question?
one of the confusing factors, I think, is that the word intention has been used in a number of different senses in the course of the case law that has developed in this area. And certainly in the judgment in Woolen, Lord Steyne acknowledges that the Crown did not contend in that case that the appellant desired to kill his son or to cause him serious injury. And so there arises an important distinction between the issue of what Mr. Woolen desired to happen and what, as a matter of law, he intended to happen. And for my own part, I wonder whether, in fact, rather than to use the word to find in substitution for the word to infer, as Lord Hope suggests, the appropriate vocab is to impute, because we're dealing with a situation where the Crown do not contend that, as a matter of fact, a particular result was desired by the appellant, but are suggesting that the circumstances were such that, given his awareness of the elevated risk of death, the law should fix him with liability, notwithstanding the fact that he did not desire the result, because he decidedly took action which he appreciated, opened up that substantial risk of death. Now, is that an appropriate way to proceed still, or does this case, your case, demonstrate that there is a shortcoming in Woolen?
Well, my lord, it demonstrates that there is a shortcoming of Woolen because it cannot be applied to this case in hand. In Woolen,
Well, it can be applied to this case in hand, can't it? And if we apply it to this case in hand, the answer is your client's guilty.
yes, my lord, but however, the principles from Woolen, it states that the jury are only entitled to find. They don't actually have to find intention from the fact of foresight of serious harm or death. So given if they do,
Well, if the jury are entitled to find it, and they do find it, then we're not entitled to interfere with that, are we?
yes, my lord, however, there is other later cases which suggest that if they do find this foresight of serious harm or injury, they can only use it as mere evidence of intention and not actually of intention itself.
So you're submitting that the Woolen direction ought not to be an expansion of the mental element of murder, but a guideline as to when a jury may infer from all the circumstances that a particular defendant has an intention in the common sense meaning of that phrase.
Yes, my lord.
I see. That's not really what Woolen says, though, is it? And I think if you consider what the Court of Appeal said in the conjoined twins case, it's readily apparent that the current understanding of Woolen is that there is a distinction to be drawn between desire and intention.
Yes, my lord.
Can you offer us any reason why it would be desirable as a matter of public policy not to sustain that distinction?
Sorry, could you repeat the question?
Well, it seems to me that there is a settled and established pattern of case law now to the effect that for the purposes of murder, the most serious ordinarily encountered crime, intention doesn't mean what it means elsewhere.
Yes, my lord.
Do you think that making that distinction in cases of murder and not making it elsewhere is a sustainable public policy objective or not?
Well, yes, my lord, because the previous cases from Woolen have proven that there have been different interpretations of Woolen. The case of Matthews and the case of the Crown and Matthews, they found that intention, that foresight of serious harm or death was the mere evidence of intention, whereas in the case of Art, Ray and children, they simply found that it was intention itself. So there is a clear.
Are you going to refer us to Matthews?
Yes.
I'm not as familiar with that case, so I'd be very grateful if you would.
Yes. If you may turn to tab B
Yes?
of your bundle, where it says, page 1, section highlighted in yellow, it was held dismissing the appeals that although acting deliberately with the appreciation of a virtual certainty of death did not amount to an intention to kill, it was evidence from which intent could be inferred.
As I understand your point, that's what you're seeking to develop here. It's essentially, it's simply evidence from which intention can be inferred as opposed to evidence of the intention itself. And that's how Woolen seems to have been interpreted in Matthews and Elaine. Yes.
From the principles of the case of Matthew and Anne, there is a similarity between that case and the case at hand. My lord, in the case of Matthews and Allen, they threw the person off a bridge. However, they had no intention to save him, whereas here, whenever an appellant threw Ross out the window, it was a completely different situation, my lord. In the case at hand, they had an intention to save the baby. In the case of Matthews and the Crown, Matthews was convicted of murder because he did not have an actual intention to save the victim. However, in this case at hand, the act itself was an attempt to save the baby. It was not an act of malice as was in the case of Matthews.
Yes, in Matthews it was a gratuitous act of violence where they threw a non-swimmer off a bridge, whereas here the throwing out of the window is done with the purpose of...
To save the child.
Yes.
Well, I'm grateful for the reference to Matthews, but Matthews, of course, is a Court of Appeal case, isn't And so if we were to conclude that Matthews was in tension with Woolin, although in fact we could overrule Woolin, Woolin would be the more persuasive precedent, wouldn't it?
Yes, my lord. Another point of submission, my Lord Smith, is that the facts of the case at the Crown and Woolin completely differ from the situation at hand. My Lord, in the case of the Crown and Woolin, the defendant lost his temper at a crying baby. However, and he chose, in losing his temper, to throw that baby across the room. However, in this situation at hand, the appellant did not willfully choose to throw the baby out the window. He simply acted in a manner which was his only option in order to try and save the child. My Lords, I would also like to make the point of...
Do you say that it wasn't a voluntary act? Because I think the word voluntary is used in the judgment in Woolin. Do you say it was a voluntary act?
Well, my Lord, no, it wasn't. He didn't have an option in the situation. There was a fire in his flat. The blaze of flames were approaching him. It was a gas explosion, and the appellants were on the 5th floor of the flat, and the fire reached the flat within minutes. The blaze was approaching them. It was a 3-month-old baby. He would obviously die within minutes with the smoke inhalation. It was his only option to throw the child out the window.
That may tie in better with the submissions that you make pursuant to your skeleton in relation to necessity and perhaps A.
Also, my Lord, the principles of Woolin should only be applied in rare situations. If I may refer your Lordships to tab C of your bundle to the case of the Crown and MD to page 6 of the case, to the section highlighted in yellow where it states, Woolin is designed to help prosecution to fill a gap in the rare circumstances in which a defendant doesn't act with the cause of the death without the purpose of killing or causing serious injury, but in circumstances where death or serious bodily harm have been a virtual certainty. My Lord, this point of law was introduced in order to ensure that those who actually did intend the harm would not get away with it, by seeing if the threat of serious harm or threat of serious harm was a virtual certainty. My Lord, it is not the purpose of the law to condemn those who are merely innocent agents and have the best intentions at heart. The appellant is not trying to escape liability for his purposeful actions. Instead, here it is a father-son relationship who simply acted out of a duty of care in order to save his son. He did not intentionally impose the harm on him, and had there been another option available to him, he would have took it. My Lord, it also states in the fact pattern that it was miraculous that the appellant and his daughter survived the fall. My Lord, that is why he threw the baby out the window, for the chance that he knew that it was more likely that the baby would survive if he threw them to the crowd in the mere hope that the baby would be caught.
You say a line should be drawn clearly between the Woolin example and this case because of the qualitative difference in the reason for the throwing of the child. Have you thought about examples of where the line might actually fall in terms of dividing the two types of case?
Well, my Lord, again, this has been the problem with Woolin. There has been different interpretations, and I do believe that the law, it needs to be clarified to distinguish the differences between these cases.
Was there any direction on the issue of necessity in Mr. Bing's trial?
Sorry, my Lord?
Was there any direction to the jury by the trial judge in Mr. Bing's trial on the issue of necessity? I'm looking at the summary of the facts that we've got. I don't see that there was.
No, my Lord.
Do you say there should have been?
Yes, my Lord, I think.
A question, my Lord, Lord Douglas Jones asked a moment ago about the Nedrick direction, which is revisited in the Wooling case. And unfortunately, I can't refer you to the passage in either of the bundles because it doesn't look as if you've photocopied that section of the judgment. But are you familiar with what I mean? The example direction that Lord Lane formulated in Nedrick, which is largely adopted by the House of Lords in Woolen. You'll recall that their lordships on that occasion concluded that the first portion of the direction was defective because it posed questions to the jury which would not have assisted them. And I imagine that for that reason, the trial judge in this case, your case, did not give that part of the direction. But as my lord has identified, the first question, hypothetical question, which the jury were invited to consider in that sample direction, was how probable was the consequence which resulted from the defendant's voluntary act. And it seems to me that perhaps deleting that question from the direction has diluted to some extent that element of the jury's consideration when only concerned with what's termed the second part of the direction, is B onwards. And as I understand it, your submission is that this was not a voluntary act because he had no real choice to make. And it does seem to me that it's unclear to what extent the trial judge dealt with that issue in the lower court. If we're not clear as to how the trial judge dealt with it, how do you suggest we should resolve the issue?
Well, my lord, I think that the law of Woolen needs to be changed in order to allow for these circumstances where they're faced with no alternative but to do that.
Now, you said a moment ago that Mr. Byng was not trying to evade liability. And did you mean by that that he accepts some criminal liability for what happened?
Well, it's not. He is not criminally liable for it because he did not have another choice in the matter. It's not as if he did this intentionally, as to try and escape, but he had no other choice in the matter, so he cannot be held criminally liable for it.
You see, if we were to conclude that you were right and that the conviction for murder was unsafe, what would you say about us entering an alternative verdict of guilty of manslaughter?
Well, my lord, given the situation, I don't think this is applicable to the case because he had no other choice in the matter. It was the baby, had he left the baby in the building and jumped out by himself, the baby would have died also. He did have the intention to save the child by throwing it out the window into the crowd.
In which case, it must follow, must it not, that recklessness would have to be adjusted in the same way as intention, so that the usual Cunningham test could be disapplied. Did you want to develop something in relation to necessity and in re.
No, my lord, I just wanted to make the distinction in the case of re. that there has been different interpretations of the law that has been held in Woolen, as in REA children, it was held that foresight of serious bodily harm or death was intention itself, whereas in the case of the Crown and Matthew, it was simply held to be mere evidence of intention, which is not actual evidence of intention itself.
Now, I appreciate that you may well be getting messages from over there to the effect that your time's run out, but I'm afraid we haven't quite finished yet. You've referred us to Woolen, you've referred us to Matthew and Aline, you've referred us to M and D, I think. Were there any other cases that you wanted to refer us to?
No, my lord, that was all the cases that I wanted to refer to today.
Have you any other submissions you want to make at this stage?
No, my lord, I think I've covered everything that I wish to establish.
Thank you very much.
If it pleases your lordships, my name is Amy Wells, and I shall deal with the second grounds of appeal. That is, my lord, that in light of the Ray A case, medical necessity should be available in circumstances as particular as these, and relating to conflicting medical decisions. The circumstances surrounding this case are very specific, and this is why my learned friend and I suggest a development in the law to allow doctors who have to make irreconcilable decisions between life and death lawful. It is suffice to say that doctors hold responsibilities and duties that are far beyond the capabilities to use the law. To restrict doctors carrying out their duties would be to put the law in a constricting area and to deter doctors from making such crucial decisions.
You said development in the law. Do you then perceive a material difference between the situation which confronted Dr. Geller and the situation that pertains in the conjoined twins case?
My lord, the Ray A case, as I'm sure you're aware, is a civil case, and the facts of the case are relatively similar. However, as I will go on to make in my further points, the law, as necessity as it stands as it is, needs to be developed following the Ray A case.
I see.
Am I to proceed with my submission?
Yes.
I'm obliged, your lordships. As stated, it is imperative that the law continues to alter to meet the needs as a case-by-case basis. The facts of this case at hand do not follow previous precedent of necessity and murder. In fact, they are quite distinct. May I now refer your lordship to tab E, page 50 of the case of Ray A, to the judgment of Lord Justice Burke, as it is quite important here. A resort to sanctity of life argument does not enable both rights to receive the equal protection of the doctrine supposed to provide each of them equally. In those circumstances, it seems to me that the law must allow an escape through choosing the lesser of the two evils. The law cannot say, heads I win, tails you lose. Faced as they are with an apparently irreconcilable conflict, the doctor should be in no different position from that which the court itself was placed in the performance of its duty to give paramount consideration to the welfare of each child. The doctors must be given the same freedom of choice as the court has given itself, and the doctors must make that choice along with the same lines as the court has done, giving the sanctity of life principle its place in the balancing exercise that has been undertaken. My lords, in the judgment of the whole case, there seems to be the following, that the choice of life and the sanctity of life is important, but it must be weighed against other facts.
As well, isn't the more important part of Lord Justice Brooke's judgment right at the end before paragraph 8 conclusion? I can see no difference in essence between that resort to legitimate self-defence and the doctors coming to Jodie's defence and removing the threat of fatal harm to her presented by Mary's draining her lifeblood. The availability of such a plea of quasi-self-defence modified to meet the quite exceptional circumstances nature has inflicted on the twins makes intervention by the doctors lawful.
Yes, my lord, I would submit that this is very important, but for the submission, the point that I was trying to develop was the issue that the lesser of two evils must be looked at. In this case, the fact that the child is very reliant on the life support machine and the other child would have died anyway as a result. As they were taken off the life support, it was predicted that the child would only last a couple of hours, and that was in fact true.
How significant is the factual distinction between the two, whereby in the case of Jodie and Mary, one was providing the life support system for the other?
In this instance, it's not, the distinction is not that different, because even though they are reliant on the children, in this circumstance, the life support machine was the joining of the two children. Unfortunately, as it states, there was only one life support machine that was available at the time, and Dr. Geller had to make the choice of which child to prolong the life. And as it states, there was only a chance, there wasn't even a chance that the child, Joey, would survive. So in order to make this decision, the doctor had to take Joey off the life support machine.
Does it matter that, does it make any difference that it might have been an option available to the doctor had he obtained the consent of the parents of the child on the life support machine?
My lord, there was not enough time to get this consent, and with doctors they have to make choices in regard to these sort of situations. Dr. Geller did not have the availability to ask for consent, and if Dr. Geller had not done what they did, then both children would be dead.
Can I ask you to crystallise in the same way that we asked your learned friend to do so in relation to the appeal concerning Bing, what test you say the judge should have given to the jury as a direction?
Medical necessity.
So it's medical necessity. And do you see that there's any distinction between the formulation for necessity given in the case of In Re A? Do you see there's any distinction between the medical situation and an emergency situation facing Bing?
Yes, my lord, because in circumstances of necessity regarding medical practitioners, there has to be a special escape for doctors who have to deal with issues such as this. In the case of Bing, the defence of necessity was not given to him. So, but in this situation, it was denied giving to Dr. Geller, and my learned friend and I would suggest that this was wrong.
Aren't the two scenarios analogous to this extent? You've essentially got an emergency situation, albeit one is a medical emergency in each case.
I would suggest that the case with Mr. Bing was one that he should hold no criminal liability anyway, whereas in this, there is liability, but because of the facts of the case, there can not be such because of medical necessity. As the judgment has shown, the lesser of two evils was taken into account, and it can be seen to be very relevant to this case. In the judgment, it was decided that if the clarification had not been sought, it would have not been murder because of medical necessity. In this instance, the necessity to give the life support machine to a baby who was medically decided to be capable of independent life was one of such holding. As the other child, Joey, was incapable of being dependent by themselves, it was the only choice available to Dr. Geller. May I also refer your lordships to tab E, page 45 of the judgment. Into my scales of fairness and justice between the children goes the fact that nobody but the doctors can help Jodie. Mary is beyond help. Hence I am in no doubt that all the scales come down heavily in Jodie's favour. The best interest of the twins is to give the chance of life to the child whose actually bodily condition is capable of accepting the chance to her advantage, even that has to be at the cost of the sacrifice of the life which is so unnaturally supported. My lord, in this instance, Joey was not capable of sustainable life by himself, and shown when he was taken from the life support machine, he did die 2 hours later.
This is Lord Justice Ward's judgment,
Yes.
is that right?
Yes, my lord.
Yeah. I don't much care for the phraseology myself in the particular circumstances, but immediately prior to the highlighted section, Lord Justice Ward says, Mary's parasitic living will be the cause of Jodie's ceasing to live. If Jodie could speak, she would surely protest, stop it, Mary, you're killing me. On the facts of this case, Joey couldn't say that to Ross, could he?
No. But in this circumstance, it was out of the hands of the parents and the children, but as the facts of the case show, the fact that there was only one available life support machine means that the situation can be quite related to the facts. Because even though they weren't twins, the fact that Joey was taking the life support machine and was going to die by doctor evaluation anyway, it was the same circumstance in this case. My lord, the facts that the policy here we suggest is very important, and to allow medical necessity We need to avoid consequences that are otherwise not avoidable, and to not give the life support machine would have resulted in instant death of Ross. And so the principles laid down by the Ray A case are integral into this, and my learned friend and I would suggest that these should be applied to this case. Both the children would have died if nothing had been done. At least this way, one of the children was given a chance of survival. And as a doctor, they have a duty to choose between life and death, and to go against this would be to deter doctors from making such decisions. My learned friend and I would suggest that this is a step that the law does not wish to take. My lord, to not grant necessity would seem to be too far removed from the law, and the development should be allowed to continue. The law is not there to assume that future cases cannot develop the law. In fact, that is the opposite of the common law. It should bend to fit the circumstances of the case. My learned friend and I would suggest that this is such a case where the defence of necessity should render the facts of Dr. Geller legal. Looking at all the facts of the judgment, it should seem that even though Ray A is a civil decision, it must be followed in this circumstance. To convict Dr. Geller of murder would seem absurd in these circumstances.
What about manslaughter?
My lord, if we convict Dr. Geller of any such charge of homicide, would be to put the law into a very confusing place. To not allow doctors to make such decisions would be devastating on future effects. And the case at hand shows the fact that Dr. Geller had to make this choice, and she had to make this choice knowing all the situations of the case. The fact that she was put under pressure and the fact that there was only one life support machine is very important here. To convict Dr. Geller of even manslaughter, my learned friend and I would suggest that this would not be suitable. My lordships, I see that my time is up.
Do you have any other submissions to make?
No. I would conclude that the appeal should be allowed and that Dr. Geller should not be found liable.
Thank you very much. Yes, Mr. Shirley.
I leave for the Crown and will be arguing the first point of appeal, that is that the will and direction was correct in these circumstances, that Mr. Bean was aware of the virtual certainty of Ross's death, and therefore the jury could conclude that he had the requisite intent for murder. If I may begin with my assertion,
Yeah.
my lordships? I'm obliged. The first case I would like to draw your lordship's attention to is the case of Woolen itself. In the judgment of the case, if you turn to tab 1 of your bundles, the second page provided to you, the court outlines that the Woolen direction is to be used in limited circumstances where there is little other evidence from which the jury can consider intent. Normally the situation would be where there is the admitted acts of the defendant, as is the case here. The Court of Appeal held that the phrase virtual certainty should be confined to cases where the evidence of intent is limited to admitted actions of the accused and the consequences of those actions. It is not obligatory where there is other evidence to consider. And if you then turn over to the next page, they continue on. It may be appropriate to give a direction in accordance with Nedrick in any case in which the defendant may not have desired the result of his act. It can clearly be seen from this that the will and direction would be appropriate given the facts of the present case. He was aware of the virtual certainty as is admitted to in the fact pattern, and therefore would have the requisite
Yes,
intent.
you accept that Mr. Bean did not desire Ross's death?
I would completely accept that fact, my lord. It would not be the Crown's intention the Crown's case that he did intend the death.
And that obviously was the same concession made by your predecessor who prosecuted the case of Woolen. But unlike the case of Woolen, it's apparent on these facts, isn't it, that Mr. Byng was trying to avoid Ross's death.
In which case, my lord, a defence of necessity or other forms of defence would be potentially applicable in such circumstances. It would not change the elements of the offence.
Well, if that's right, you've got a problem, haven't you, Mr. Shirley? Because as far as we can see, the trial judge didn't direct the jury on the defence of necessity.
As far as we can see, they weren't directed on the defence of necessity, but equally, if the trial judge had refused to give a direction on an issue such as necessity, it would be the appellant who could appeal on that grounds, and as they haven't, we could infer that necessity was put to the jury and rejected by them. And therefore the Woolen direction would be appropriate and they would be able to find the requisite intent.
We assume that the direction concerning necessity was put. Do you say that that's appropriate?
Yeah, without having the benefit of being the counsel for the original trial, I don't have the benefit of having the full facts. The elements of necessity would be a question for the jury. On the facts, they may be applicable, as we see them at the moment, but without a full hearing, I would not be able to say whether or not it was fully satisfied for the jury.
I mean, in the absence, surely, of clarification, we have to assume, don't we, that the trial judge directed the jury in terms of the Nedrick direction, which is approved by and large in Woolen. And reading from that, it's not, I think, in or bundle. On the other hand, if the jury are satisfied that the material crime the defendant recognised that death or serious harm would be virtually certain by some unforeseen intervention to result from his voluntary act, then that is a fact from which they may find it easy to infer that he intended to kill or do serious bodily harm, even though he may not have had any desire to achieve that result. Well, the appellant contends, and there's surely some force in the proposition, isn't there, that this wasn't a voluntary act, because Mr. Byng had no meaningful choice to make. If he'd done nothing, he, his daughter, and his son would all have died in the fire.
There were options available to him. He could have thrown they were in a bedroom, he could have thrown the mattress out to cushion their landing, which it would be in keeping with my fourth submission, that any action to mitigate the risk would be enough to bring it outside of virtual certainty. As no action such as this was taken, it falls squarely within virtual certainty.
So you'd say beyond that, that undermines the second two principles of necessity as set out in In Re A, is that right? In other words, he didn't do no more than was reasonably necessary to achieve the purpose, and the evil it inflicted was disproportionate.
Yes, my lord, that could be the basis if the necessity was put to the jury why they rejected the defence. That he did nothing to mitigate the harm, and therefore it was at least as bad, if not potentially worse, than the harm that was expected of Ross. On the facts as we see them, the emergency responders started to arrive, I believe it was within a minute of Ross landing outside.
That's agony of the moment territory, isn't it? Because he wouldn't have known that.
He wouldn't have known that, but if he had waited till in my learned friend's submission, they said that the baby would have died within a matter of minutes. If that was the fact of the case, then he should have waited until the absolute last moment to throw Ross from the window to maximise his chances of survival. Or as I've suggested, throw a mattress out, throw a duvet out, get the attention of someone in the crowd so that there's a nominated person who's going to attempt to catch him rather than just simply throwing him out the window. There are options he had and didn't take, and that would be why a defence of necessity would not be applicable and why the Woolen direction would be.
Well, to my mind, that sort of language is reminiscent of the contention that Mr. Byng's breached some sort of duty of care that he owed to his children. And of course, a parent does owe their children a duty of care, particularly the children of this age. But we're not talking about manslaughter here, are we? We're talking about murder, the most serious crime that in the ordinary course of events any human being in this jurisdiction is convicted of. Deliberate killing of another human being, which, as you know, results in a mandatory life sentence.
Yes, my lord, and in this case it would be applicable as murder rather than manslaughter. This was a voluntary act to throw Ross out the window. He is in keeping with the Woolen direction, with Woolen that he had the requisite knowledge of the consequences and they were virtually certain. It may be helpful if I direct the Lord's attention to tab 3 of your bundle, the case of Rie. And this third case that I provided to you at the top. Unpalatable though it may be to stigmatise the doctors with murderous intent, that is what they in law will have if they perform the operation and Mary died as a result.
I'm sorry, I haven't followed you through your bundle. Which tab am I at?
Tab 3.
Tab 3.
The third page of the case that's been provided.
Yeah.
This clearly shows that whilst it may seem odd to characterise it as murder, it is an intent for murder, and therefore, barring some other defence operating, you could hold Mr. Bing liable for the murder of Ross. Have I lost your lordship?
No, I'm just thinking through the implications of your submission. What troubles me is that the law was obviously in a state of some considerable disarray until Woolen came along. Since Woolen, it seems as though things have settled down to some extent. And you would, of course, say that we should continue to respect Woolen's authority and continue its effect in this case. But there does seem, on the appellant's submissions, to have arisen some confusion about whether Woolen was provides a basis in law for constructive intention, in the sense that, as a matter of law, an individual who does not, in the ordinary sense, intend a particular result can be held liable as if he did, or whether, in fact, the Woolen direction, or Nedrick direction, perhaps more accurately, is a basis upon which a jury can make a finding of fact, and is in fact intended to limit the circumstances in which a jury will make a finding of fact to the effect that they are satisfied that intention is made out by an analysis of the surrounding circumstances, the risk of harm, and whether or not that risk was perceived by the individual with their concern. So do you say that Woolen adds to the necessary mens rea for murder to the extent that, in addition to intention, in its ordinary sense, to kill, or of course grievous bodily harm, there is this additional intention which will suffice in order to establish liability for murder? Or do you say that on the proper analysis, which I think is that preferred by Lord Justice Ricks in the case that we've been referred to, Matthews and Helene, it is merely a guide to how the jury may approach the question of intention when concerned with circumstantial evidence?
It would be the submission of the Crown that it would be the latter of the two choices, that it is evidence of intention rather than being a new form of intention in and of itself. On the facts at present, it would still be strong enough evidence to find Mr. Bing guilty. An interpretation of it has been that what it is such a foresight of the virtual certainty is evidence, there needs to be something else that will convert that into a full evidence of intent. My learned friend mentioned that it is an entitlement of the jury to find the intent, not any sort of obligation upon them to do so. And if there's ever...
Well, the trouble with that, Mr. Shelley, is the formulation of the direction that we've got in the summary of facts. Admittedly, it doesn't say if you find really serious, a virtual certain risk, and he appreciates it, you must convict of murder on that basis. But what it says, I'm troubled by the words "on that basis," because it seems to suggest, doesn't it, that no more is needed. You only need to be satisfied of those things. You don't need to make any further inquiry of Mr. Bing's state of mind, and specifically, presumably, you don't need to inquire into whether, in fact, his intention was to avoid Ross's death and not to cause it.
You appear to be correct, my lord.
They were entitled to convict him of murder on that basis, i.e., without any further inquiry.
without any further, I would submit without any further inquiry, yes, the evidence as it appears was strong enough on that basis. The only other evidence that would be presumably Mr. Bean's own testimony